Let me first say, I am a professor of international criminal law. I teach every summer in our Nuremberg summer school program. And so where I begin in looking and answering your question is I look at the Nuremberg precedent, what happened in Nuremberg trials. And so I'd like to just, in order to make it more interesting, I'm going to share my screen. And I want to okay, can you see?
Everything is
Yeah.
Yes, you should be seeing on your screen, delivering Nuremberg-style justice to Ukraine war perpetrators. Is that visible to everyone?
Yes.
Okay,
Yeah,
very good.
it's visible.
Okay, so what I want to do is to bring vocabulary here in certain way of saying. I think it's important for us to, when we talk about the prosecution of the perpetrators, to go ahead and refer to Nuremberg, because Nuremberg provides the best precedent under international law for the prosecution of the forced transfer of children, and I'll explain this in a moment, and in general for all the other crimes that are occurring in Ukraine. So just as a reminder, I know all of us are experts, but just to, when we speak about Nuremberg, we are focusing on, see here? Okay, on 1945, the International Military Tribunal for the prosecution of the German war criminals, where 22 defendants stood trial, not for a violation of domestic law, but for international law. And these are, we all know, the international law crimes that they were charged with. What is really critical is we also know that they were charged and decided before 4 judges, each of the 4 allied countries. Here's the photograph of the judges. But what is critical to remember that at the end of the trial, and it began on November 20th, 1945, and then on October 1st, 1946, is that not all of the 22 defendants were found guilty. In fact, 3 were found not guilty. And people forget that. And that's a very important point, because when I mean Nuremberg-style justice, I don't mean Stalinist justice. I don't mean Putin-style justice today. I'm talking about a situation where the prosecution has to prove that the crimes that the individuals are being indicted, that has been proven beyond a reasonable doubt. And in Nuremberg, this is for the major war criminals, the judges, at least the Western judges, felt that there was not evidence, and 3 individuals, 3 major Nazis, were able to walk out of their courtroom. Now, the Nuremberg main trial did not end with the trials. There were then, in the American zone and other zones, other trials, and then the most famous were the trials in the American zones. And the one that is most relevant today is the Russia trial. I have here on the screen 14 defendants. They were all leading officials of the Nazi Race and Resettlement Office, and their job was the implementation of racial programs. And what did they do? They were, involved in the kidnapping of racially valuable children for Aryanization, for Germanization. And the chief defendant was an economist who was working for the SS, who was working directly under Heinrich Himmler, and he was sentenced to life in prison because the program that he put together. In the trial itself, and I'm looking at the judgment, the individuals were charged and found guilty of both war crimes and crimes against humanity. And in the program itself, the judgment brings out that this was a program of Germanization. The object of the program was to strengthen the German nation and the so-called Aryan race at the expense of such other nations and groups by imposing Nazi and German characteristics upon individuals that were selected for the Germanization. And these individuals end up going to trial. And as you notice here, there was, again, Nuremberg-style justice. One was acquitted. Mr. Greifeld was sentenced to life in prison. He actually died in prison, and other individuals were given terms between 10 to 25 years. So it's really important to see that Nuremberg establishes that the act of kidnapping of children amounts to a war crime and amounts to a crime against humanity, and that is existing precedent. I want to point out to one of those witnesses, and you can see here, this is a young girl, 15 years old. She was kidnapped from Czechoslovakia, and because she had blue eyes, blonde hair, she was sent to a German family, and she was there in order to go ahead and become German. For 1942 to 1945, she was living with the German family. She could not end up speaking any Czech. She forgot actually how to speak Czech, and she was made German. So, but the answer I want to give is yes. And the other point I want to make is, and you asked the question, is it genocide? And the answer is it is genocide, because under the Genocide Convention, you have the forced transfer of children is considered one of the acts of genocide. And the reason why that act is put into as one of the ways that genocide was committed is exactly as a result of the decision in the Russia trial. So in the Russia trial, genocide was not charged as a crime, but it was described as genocide through war crimes and crimes against humanity. Now, under the Genocide Convention, it is also genocide. And I will stop here.
Were you ever examined while in the camp at Liechtenstein?
Najpierw spóźniłem wytrzymać tego. No,
How long did you stay in this camp at Liechtenstein?
jak długo to zostali wytrzymać w tym pewnym taborze?
Myśmy byli z tymi ostatnimi dziećmi tydzień w Łodzi.
We stayed in Liechtenstein for a week.
How were you treated while you were in the camp at Liechtenstein?
Jak się z wami zachowali sobie w taborze w Łodzi?
W Łodzi się z nami zachowywał świetnie.
We treated very badly in Lodz.
And after leaving Liechtenstein, where did you go?
Pісля опустя Лodz, там стояли.
Jeliśmy do Liechtensteinu.
Then we went to Liechtenstein.
Dzieci z leżaku,
To our children from Leżaki,
Wacław Zelenka,
Wacław Zelenka,
a Hanna Szpotowa.
and Hanna Szpotowa. So dzieci.
The last two which you just mentioned, Omega and Spotova,
A te poslední dvě, které jsou řekla,
they were children from Liechtenstein.
to byly dětské děti. Yes, those were two Indian children.
And they had been with you at Kladno in the beginning. Is that
To
correct?
by s vámi vkladně na začátku, že ano?
While you were at the home Bush Scout, what did you do all day long?
Když to bylo v Buskandově po škole, co se s vámi dělal?
Museliśmy chodzić do szkoły,
You had to go to school,
uczyć niemiecki,
learn German,
tak,
write,
poczytać,
count,
czyć,
read,
zdrawiać,
read,
a działać sobie takie.
and we had to work too.
Did they tell you about Czechs in the home Bush Scout?
Co vám řekli o Češích v dětském domě po škole?
Że budeme Niemcy a Niemki,
They told us that we were the Germans,
że się asi zpět nevrátíme do Československa,
and never would probably come back to Czechoslovakia.
But going back to Bush Scout once more with us,
Vrátíme se ještě jednou zpátky do Puškova.
how long were you in Bush Scout
Zažil jsem zůstal v Puškova.
all together before going to the Richter family?
Dohromady nešli jsme zpátky do Richtové familie.
tam jsme byli přes rok.
So we stayed about a year.
And repeat after me.
बड़े ठीक साहब
I swear by God,
ठीक साहब से बोलो
Přísahám při Bohu,
the Almighty and Omniscient,
všemohoucím a vševědoucím,
všemohoucím a všemohoucím,
that I will speak pure truth,
že budu mluvit upřímnou, čistou pravdu
že budu mluvit ti přímo čistou pravdu
and will withhold and add nothing.
že nezapřu a že vše řeknu.
že nezapřu a že vše řeknu.
Můžete se posadit.
Do you remember what happened in Lidice at that time?
Vzpomněte si, co se stalo v Lidicích v této době. Yes.
Will you please tell the tribunal what happened to you?
Řekla byste, co?
Nakázal, aby jsme si sebou vzali papír a ten,
They ordered us to take our papers and our money,
a že musíme na několik dní do školy.
and that we had to go to the schoolhouse for several days.
My jsme se dali vodit na diváky do Tape.
When we took everything with us, we were led to the Horax farm.
Teď jsme spali několik hodin.
Here we stood for several hours. It's too long.
Rothenberger. In the counts of the indictment on which you have been convicted, this tribunal sentences you to 7 years imprisonment. You will receive credit upon your sentence for the time already spent in confinement, awaiting and pending trial. The marshal will bring before the tribunal defendant Ernst Laus. Ernst Laus, on the counts of the indictment on which you have been convicted, this tribunal sentences you to 10 years imprisonment. You will receive credit upon your sentence for the time already spent in confinement, awaiting and pending trial. The marshal will produce the defendant Wolfgang Metkenberg. Wolfgang Metkenberg, on the counts of the indictment on which you have been convicted, this tribunal sentences you to 10 years imprisonment. You will receive credit upon your sentence for the time already spent in confinement, awaiting and pending trial. Defendant Wilhelm von Amen, to 10 years imprisonment. You will receive credit upon your sentence for the time already spent in confinement, awaiting and pending trial. The marshal will remove this defendant from the court and will produce the defendant Gunther Joe. The Gunther Yoel, on the counts of the indictment on which you have been convicted, this tribunal sentences you to 10 years imprisonment. You will receive credit upon your sentence for the time already spent in confinement, awaiting impending trial. Marshal will remove this defendant from the court. Defendant Oswald Grotow, on the count of the indictment on which you have been convicted, this tribunal sentences you to imprisonment for life. The marshal will remove this defendant from the court. Rudolph Eschai, on the counts of the indictment on which you have been convicted, this tribunal sentenced in the court and will produce the defendant Joseph Alstetter. Joseph Alstetter, on the count of the indictment on which you have been convicted, this tribunal sentences you to 5 years imprisonment. This military tribunal now stands adjourned without day.
So to go back, yeah, we are clear that under the Nuremberg precedent that there is the kidnapping of children is a war crime and a crime against humanity. And as a result of the Russia decision, Article 2 of the Genocide Convention includes the forced transfer of children as one of the acts of genocide. So that is also clear. So to answer your question, it is war crimes, crimes against humanity, and also is genocide. All three could be charged.
Let me start with disclaimer, because I'm the member of several organizations, including international organization. I'm an expert for them. So the position expressed during this session are mine and do not represent the views of the organizations or institution I collaborate with. And we'll speak, I hope we'll have a discussion, and the questions I will try to cover are the factual situation of the deportation and forcible transfer of Ukrainian citizens and especially children, the legal regulation of the prohibition or legal qualification of the prohibition of deportation and its application in the context of this armed conflict, and the avenues of prosecution for deportation. And we'll wrap it up with current actions in response to these deportations on national, international level, and the gaps in national legislation and practice and recommendations. Let me start with the qualification of the armed conflict in Ukraine, because it is important in IHL dimension in application of the rules of international humanitarian law, IHL rules. Russian-Ukrainian international armed conflict began in February 2014, no later than 20s, because on 27th of February 2014, Crimea was under control of Russian military forces. It was occupied already, and we can count this date as the beginning, but actually the beginning was earlier with the invasion of Russian troops to Ukrainian territory. And it was the first phase of this international armed conflict, which continued with the occupation of parts of the Donetsk and Lugansk regions by Russian forces which invaded to these territories, and by proxies under the control of Russian Federation. And now we have the proxy occupation of those territories until, until the third phase, until the full-fledged invasion of Russian troops and this shelling of the territory, all over shelling and bombing of the territory of Ukraine started on 24th of February 2022. It is the third phase. So there is no separate so-called Donbas conflict, Crimea, the Donbas conflict, there are no separate conflicts. It is one international armed conflict, and the legal regime of our international armed conflict is applicable to this situation. Let me start with the factual, the facts describing the situation in Ukraine and describing the coercive environment, which is actually the basis for deportation and one of the elements, because as you know, Russia says that it was evacuation of Ukrainians, not deportation, and there is a difference between evacuation and deportation, and this difference lies in this word forcible displacement, forcible deportation or transferring of people or children. So from the beginning of this armed conflict in 2014, Russia has been engaged in deportation of Ukrainian citizens. For example, lots of prisoners were deported from Crimea to Russian Federations since 2014. There were lots of attempts, sometimes successful, but mostly not successful because children were returned, but such attempts had taken place. For example, children from Snizhne in 2014 who were going to Dnipropetrovsk at that moment, they were abducted by the DPR organized armed groups, DPR fighters, Donetsk People's Republic's fighters, and deported to Russian Federation. Immediately, Ukrainian authorities reacted to this situation of deportation of Ukrainian children, and they were returned. Pavel Astahov, the children's ombudsman for that moment in the Russian Federation, he immediately reported children were returned, and it was, the situation was resolved, at least for that moment. But since the first weeks of its full-scale invasion of Ukraine in 2022, Russia has created these coercive conditions in which civilians in the temporary occupied territories have no choice but to go for or through Russian Federation. Russia deliberately created a humanitarian crisis in the captured cities. Mariupol is the best example of it. Russia blocked Ukrainian green corridors and forcing the local population to flee to the Russian Federation. Ukrainians who immediately appeared in the occupied territories and wanted to leave for the control territory of Ukraine were forced to break through the front line, where the Russian army set up dozens of checkpoints and in many cases fired at people. If people were lucky not to be shot or shelled to appear in the shelling, they were told that by Russian military forces that Russia already occupied all the territory of Ukraine, that it is ruined, and you have no point, no reason to go to the territory under the Ukrainian control. So please go to Donetsk People's Republic or to Russia. So they were like pushed to go to Russia. Those who tried to leave these territories by their own, by themselves, they, of course, they choose the route to Crimea or to Russia, and these routes definitely were safer. For those who were deported in this so-called Russian evacuation corridors, those buses, there were no other choice. They were put, children, for example, they were put in these buses and possibly deported. And let me illustrate it, cursive environment with these photo examples. This is Mariupol, the residence area. I'm sure you've seen lots of those photos from Mariupol. This is Izum, the center of one of the cities in Kharkiv region. There were no city fighting for that moment. All ruins, and the center of the city is ruined totally. All ruins are the result of direct bombing and shelling. This is torture cellar in Kazachalopan. It's also Kharkiv region, and lots of civilians were tortured and detained in those cellars. I'm sorry, and not all of them survived. And you see the, I'm sure you've seen lots of photos from I don't know, cemetery near Izum, where more than 440 graves were found. And here you see the photo of those burials. Almost 900 bodies were found in the region. They were results, their death is a result of shelling, bombing, torturing, rapes, sexualized violence during this armed conflict. And you see the convoy of civilians who tried to evacuate from Kupiansk, and this is the road between Kupiansk and Swatovo, Kharkiv region as well, and the civilians were shot. 20 civilians, 20 adults were killed, including 10 children inside their cars. Directly. Number of deported citizens, deported civilians, I can say. With each passing month, the number of Ukrainian civilians being transported from the temporary occupied territories to the Russian Federation has only increased. According to UNHCR, by November 2022, more than 2.8 million of Ukrainian citizens had crossed the border with Russia. Not all of them deported, but almost 3 million crossed the border. According to Russian FSB Border Service, by mid-August 2022, more than 3.2 million of people, including more than 500 children, has entered the Russian Federation. It is official data of Russian Federation. According to open sources in the Russian Federation, the number of children taken from Ukraine to the Russian Federation may be as high as 733,000 children. According to the Ukrainian National Information Bureau, the total number of deportees for the period from 24th February to the 1st of November, I have only these data, was almost 46,000, including more than 8,000 children. As I already told, this information is based on daily reports from the authorities of all the levels, verified information, reports from relatives and friends, and partly on information from open sources. But all of these children, the information about children it's not only the name, it's more than a name information. And you see the Children of the Children of War web portal, DTVNI in Ukrainian. As of today, it's nowadays information. The portal lists 19,393 children as deported or forcibly transferred. It is deported because we have no access to them. They are under the control of Russian Federation, and only 361 kids returned. You see the difference. It's returning of every child. It's a huge process, very difficult but important, of course. The patterns of deporting children from Ukraine. The first is that children have gone missing during shelling and hostilities, especially Mariupol and other regions where there were huge shelling and destruction of the residence areas. Kids were taken from the basements and deported to Russian Federation, and nobody even interested where they have relatives. Nobody informed Ukrainian authorities who were those children, whether they have relatives, whether they have some relatives in the territory under control of Ukraine. So no connection at all. Second pattern is large-scale deportation of orphans. Lots of orphanages were deported, all with all the children and with all the workers of those orphanages, transferring children with consent of parents to occupied territories within the territory of Ukraine. I mean, it needs international borders. I mean, like transferring of children from the Zaporizhia region under the control of Russian Federation to Crimea, for example, and they received the consent of parents. But later, this transferring ends in deportation. Children were found in Krasnoyarsk area. I'm sorry, Krasnodar area, and I'll show you the examples of posts, official posts on the like news channels. So, with no permission of parents, children were deported from this so-called rehabilitation camps of Crimea or any other regions in Azov Sea to Russian Federation. Use of filtration camps where parents had become the detainees for several days or even weeks or months, and their children were deported in this time. Killing of parents and taking their children. Not a huge amount of such cases, but of course they exist. And the new pattern, possible mobilization on the occupied territories and taking deaths from the families. And after that, they came and say that mother did not provide her children or her child with proper care, of course, what a cynicism, and they deprive her of parent rights and take her children, a child, and deport it to Russian Federation. And you see some quotes. For example, the first is from Maria Lvova-Belova. She said that orphans, in particular children from boarding schools, have been taken to Russia since late February, immediately after the large-scale invasion. By the middle of March, there were already about 1,500 of them in Russia. And now you see some quotes from mayor of Oleshki and mayor from Melitopol. Both of them said that children were taken and deported on buses. And for example, the mayor of Melitopol, Ivan Fedorov, said that more than today, one day, more than 300 children from Enerhodar, Kamenka, Vodane were taken to Krasnodar territory under the guise of holidays and never returned. And you see the photo from Ministry of Labor and Social Development of Russian Federation. Children taken deported from Ukraine to Krasnodar region. It's official photo. And now you see, I found the interview of Maria Lvova-Belova, where she told that the main result is the children of Donbass who ended up in families. The main result of her work. I didn't seek these directions, she said, from the beginning of this special operation, she meant. it came by itself. The result was a meeting with the President Putin. When the evacuation of institutions from different regions began, I came to the president and said, look, let's give these children who have citizenship, Russian citizenship, they mean, to families, without knowing how many were those children. And Putin answered, and why those who have citizenship? We should give them all. Wherever has the opportunity to go to a family, we have to send them all. The quotes, of course, it's hearsay, it's the words of Maria Lvova-Belova, she quoted president, but according to Russian legislation, children with other citizenship, not Russian citizenship, they could not be adopted. And of course, you see that she knew, Maria Lvova-Belova, she already knew, she's the children's ombudsman of Russian Federation, everyone knows it. And she already knew that it is impossible to adopt those children, to give them to families. And she answered, and she proceeds, and it got scary because you don't understand how to do it, because there is no mechanism, and because the children who come to us are by and large not ours. She understands that children are not Russians, but nevertheless they continue the procedure of adaptation, of adopting those children, and they enact a special legal act. They take it. And Vladimir Putin has said, another article of Russian Federation, Vladimir Putin had said that it was not necessary to introduce amendments to the law that would allow children from the DPR and LPR to be placed with families regardless of their Russian citizenship. He asked Maria Lvova-Belova to prepare proposals for the amendments. You make the proposals, we will change the legislation. We will apply to the State Duma, it's the Parliament of Russian Federation, and I'm sure the deputies of Post-History will support you. The president said in early March. On 30th May 22, Putin signed a decree simplifying the procedure for orphans from Ukraine, in particular from the territories of the so-called Donetsk and Lugansk People's Republics, to obtain Russian citizenship. This law also applies to orphans brought to the occupied Crimea, so transferred. All this makes the adoption much easier. According to Russian legislation, adopted children, the names of adopted children could be changed by the court and their origins concealed. In this case, it is never possible to trace these children because no one will share this information with you. And of course, you know that UNICEF insists, and all other human rights bodies, international human rights bodies insist that adoption should never take place during or immediately after emergencies or crises such as armed conflicts. Children separated from their parents during a humanitarian emergency should not be considered orphans. Lots of orphans taken, deported from Ukraine, they have their relatives in Ukraine. They were in orphanages, not because they don't have relatives, they have, but no one tried to find them and return children to them. Every opportunity for family reunification should be provided. Here you see this decree of the president of Russian Federation. And after that, in every in every region, you can find news that some children from Donetsk People's Republic, they try to find adopted families, not to become adoptees in those families. So you see this information from the newspaper group, like the online. A group of 38 children who lost their parents arrived in the Lipetsk region from the DPR. They have no now been placed in special institutions. So in Russian Federation, they already prepared these special institutions with all the necessary facilities. The children range in age from 8 to 17. According to the Regional Department of Education and Science, deeply involved in the process of deportation, Lipetsk residents are asked to contact the guardianship and custody authorities in their place of residence, as well as the regional database of children, the special database created in Russian Federation before that, but of course it's actively involved, people who work there, left without parental care, in order to adopt children. So come and take children, it's easy. And here you see the bus and children taken from the Donetsk region of Ukraine under this information. They have a photo. Please, you can choose any kid you like. I don't even, I'm hardly to find words to compare this situation. What are those children? Are they pets? Come and take children. In Russia, deported Ukrainian children are massively militarized and brainwashed at schools and special camps to change their identity and turn them to love Russia. Russian ombudsman Maria Lvova-Belova, who herself adopted the child from Ukraine, from Mariupol, said during her speech in the public chamber that at the beginning, the Ukrainian children spoke negatively about the president of Russia, said all sorts of nasty things, sang the Ukrainian anthem. But then they ended up in Russian foster families and integration began. And the negative attitudes of Ukrainian children turned into love for Russia. What do? I'll show you. Here you see the photo of so-called Yunarmia. It's a youth organization where children are prepared to take part in hostilities. You think that there are only older children? No, there are different of them, and they are educated how to take part in hostilities. Even in kindergartens, they provide their policy of militarization and brainwashing children. And Maria Lvova-Belova, the minion of Putin, is actively involved in this. And you see, she visits all the camps where children were taken, deported from Ukraine, and try to brainwash them and to push them to love Russia and the president of Russian Federation. So these facts show you the chain of command. At her meeting with Putin on 16th February 23, Russian Ombudsman for Children's Rights, Maria Lvova-Belova, thanked him, I'm sure you can see this video, for making it possible for her to adopt the Mariupol child herself and for making it easier for Ukrainian children to be adopted in general, saying it was all thanks to him. Putin smiled gratefully and nodded in agreement. As you can see from her quote, from the interview before I showed you, it was his idea to pass the decree making the adoption easier, and he asked her to draft it. Interviews like this help to trace this chain of command right up to the top for the crimes of deportation during the Russia-Ukraine war. But it's not only those, Putin and Maria Lvova-Belova. The whole machinery of Russian authorities is involved in this crime, from the president, ombudsman, to the governors of the regions that receive children, and all over Russian Federation, the children were displaced. The territorial departments of family and childhood, those who organized deportation from the occupied regions, organized transfer, changed the names of adopted children, and so on. On the website of the Krasnodar Territory Department of Family and Childhood, they already said that 1,000 of Ukrainian children taken from Mariupol had been put up for adoption only in this region alone. It's the information from Russian official authorities. And another 300 are currently undergoing. After the scandal, they take it off, this information, but of course you can understand that in 21st century, you can't hide information from the internet. You see this meeting and discussion and encouragement of each other for the deportation. And now for the legal qualification. In international criminal law, deportation, forcible transfer is not in itself an international crime. It could be classified, as Professor Bedler has already mentioned, as a war crime, a crime against humanity, and under certain circumstances, genocide. In the IHL dimension, deportation, forcible transfer is a serious violation prohibited by the 4th Geneva Convention, Articles 49 and 147, which lists the grave breaches of IHL, the war crimes. It's not, the article has no these words, but grave breaches are the war crimes. It's additional Protocol 1, Article 78 and Article 85, and customary international humanitarian law, Rule 129A, which says that parties in an international armed conflict may not deport or forcibly transfer the civilian population for an occupied territory in whole or in part unless the security of the civilians involved or imperative military reasons so demand. Later we'll discuss those provisions. In ICL, international criminal law dimension, deportation and forcible transfer may be qualified as war crimes, as crimes against humanity and genocide, and these crimes are not mutually exclusive. One act could be qualified both as war crimes, as crimes against humanity and genocide. Of course, if they have these common or chapeau elements, such as, for example, for war crime, that nexus of the act committed and armed conflict with the knowledge of this nexus, so mens rea and actus reus elements. And if the same act was committed within widespread or systematic attack against civilians, has those chapeau elements of crimes against humanity, it also could be qualified as crimes against humanity. What are the elements of deportation and forcible transfer? What is the definition actually? And the ICTI, International Criminal Tribunal for the former Yugoslavia trial chamber in Radvan Karadzic case prescribed that the elements of deportation and forcible transfer are substantially similar. Deportation and forcible transfer are defined as the forced displacement of one or more persons by expulsion or other forms of coercion from an area in which they are lawfully present without grounds permitted under international law. And the difference between deportation and forcible transfer lies in the national border. In case if they were this border, national border, was crossed, it is deportation. And in case if people were transferred within the borders, I mean within the occupied territories, but the internationally recognized territory of Ukraine, for example, from Donetsk region to Crimea, it is forcible transfer. Interpretation of the term forced. Deportation is illegal only if it is forced, and the term forcibly should not be interpreted as in a restrictive manner, only like physical force, as concluded in Krone Yalat's case by the ICTI, the creation of conditions in which civilians feel fear of violence or threat of detention or abuse of power or other forms of psychological violence constitutes coercion to deport or forcibly transfer. In above-mentioned Karadzic case, the forced character of the displacement is determined by the absence of genuine choice by the victim in his or her displacement, As such, while persons may consent to or even request their removal, any consent or request to be displaced must be given voluntarily and as a result of the individual's free will, assessed in light of the surrounding circumstances of the particular case. I've shown you the surrounding circumstances of this coercive environment. Of course, people were trying to escape this coercive environment and deportation taken place. And this situation of coercive environment was acknowledged by lots of international non-governmental organizations and special expert missions, such as the expert mission of the OSCE Moscow mechanism. Limited reasons to deport. The difference between evacuation and deportation. Of course, Russians say that they evacuate. Let's find the difference. First of all, according to Article 49 of the Geneva Convention, the Fourth Geneva Convention, the occupying power may undertake evacuation if there are no other ways to keep those population out of danger. According to the ICRC commentary, International Committee of Red Cross commentary to this article, evacuation for public safety or compelling military reason is possible only inside the occupied territory. The evacuation of civilians outside the occupied territory, means deportation in our case, is allowed only if it is practically impossible to evacuate the population inside the territory, and the population is in danger, for example, from intense bombardment by the opposing side, Ukrainian side. To my knowledge, no intense bombardment by Ukrainian side were committed during this war. Ukraine did not shell and bombed residential areas. And immediately after the occupation of those territories, even before the occupation according to the Article 42 of the Hague Convention, this deportation started. And according to Professor Sassoli, it doesn't mean that all control was established, the overall control was established over the areas. So-called functional occupation is also taken into consideration. So immediately after the invasion, even before the occupation, even before establishing the control over the territory, the deportation of civilians could be qualified as deportation. It should be emphasized that Ukrainian citizens were often forcibly deported to Russia from areas that were immediately captured. For example, Kharkiv region, no fighting took place, no danger at all, but they were deported from those territories. And as you know, they started deportation of children even before the 24th of February. They already reported that they evacuate kids from children like facilities or orphanages from the so-called DPR area. And as you see, there is no words about returning these people. There is no access to those who have been evacuated, so-called, and there is no lists of those people, of those civilians, and no access of international organizations to Ukrainians in Russian Federation. According to Russian official data, more than 3 million were evacuated or moved, displaced, as they say, but no access of international organizations till now to those people, no lists of the displaced persons, nothing. And of course, it is prohibited according to Article 49.3 of the Geneva Convention, post-Geneva Convention. Moreover, the occupying power, Russian Federation, has to give the access, to provide the access to so-called the protecting power. The ICRC can play such a role, or any other humanitarian organization can also be involved in this, like visiting the displaced persons, but nothing. Deportation as genocide. Just a few words. As I already mentioned, deportation of Ukrainians, especially Ukrainian, not all Ukrainians, but Ukrainian children to Russia can be qualified as genocide, according to Article 6E of the ICC Rome Statute. And it also could be qualified as an act of state and bring state responsibility for genocide according to the Geneva Convention 1948. And as for the crime, the prosecution of individuals for genocide, the international crime such as genocide requires careful evidence collection, which is particularly true of data and may indicate so-called chapeau elements of genocide, the special genocidal intent, and also scale is important in taken into consideration. But according to Bogasora judgment of the Rwanda Tribunal ICTR, the perpetrator need not be solely motivated by criminal intent to commit genocide. Sometimes you can hear that it is genocide only if it is the sole motive to commit the destroy the group, national, ethnic, racial, or religious group in whole or in part as such. But it should not be established that it was the sole motive, the only one motive by the criminal who committed this genocide. Nor does the existence of personal motive preclude him from having the specific intent to commit genocide. The transfer of Ukrainian children with the common language, Ukrainian language, and common culture, not only Ukrainian language culture, I mean, to Russia, with their subsequent adoption or education in Russian families and schools with the intent to destroy their belonging to Ukrainian nation, can lead to their complete transformation, changing their national and ethnic affiliation. And in this case, it should be qualified as genocide. And the representative of Venezuela noted during the drafting of the Genocide Convention that forced transfer of children to a group where they will receive an education different from that of their own group, and we see that it is different in Russia, and where they will have new customs and possibly a new language, is in practice tantamount to the destruction of their group, whose future depends on the generation of children. But those elements of intent or destructive planning should be taken into account in a whole as a pattern, with all other patterns of destructive planning and intent, such as arrest and killing of leaders in the occupied territories, arbitrary detention and forced disappearance and torture of anyone perceived to be pro-Ukrainian, politically, military, cultural, or because they are links to the security forces. As you know, in every occupied city, every occupied region, they try to persecute pro-Ukrainian locals and kill leaders, torture and kill leaders. It's also, those activities should also be taken into consideration. De facto enslavement, sexual violence, deportation of children for education. It's all the elements of this pattern, the common pattern of destructive planning and genocidal intent. As for the scale and area, according to the ICJ in Bosnia and Herzegovina versus Serbia and Montenegro, the part attacked must be sufficiently significant to have an impact on the group as a whole. And of course, if we are talking about children and transferring of children, it's not the destruction, the physical extermination of children, but it's more cultural genocide. But it also, the scale should also be taken into account. But at the same time, genocide can be established if the intent was to destroy the group, even within a limited geographical area, such area as we see is under their control. But of course, in order to establish genocide, it is necessary to place the conduct of Russian perpetrators in the context of these clear criminal practices of similar behavior that are gaining in intensity. And this approach would show the perpetrators' awareness of the overall genocidal aim or campaign and their respective contributions to that campaign. Avenues of criminal prosecution. As you know, there are different avenues, domestic jurisdiction, national jurisdiction. It's Ukraine, of course, according to the territorial principle. And of course, it could be any state which can prosecute according to universal principle of jurisdiction. As for Ukraine, criminal prosecution of deportation in the national jurisdiction of Ukraine is possible only as a war crime under the Article 438 of the Criminal Code, or as a genocide according to Article 442. But Criminal Code of Ukraine does not criminalize crimes against humanity. So such qualification and prosecution are currently possible only within the international jurisdiction, the jurisdiction of the ICC. I already told that Article 438 is a blanket rule. It allows to directly apply the direct application of IHL provisions of all the IHL treaties ratified by Ukraine. And I'm sure that customary rules as well, despite that they are not mentioned in Article 438. The name of this article is violations of laws and customs of war. So it's already mentioned in customary rules. And Article 3 of the Criminal Code of Ukraine also says that general principles of international law is a source of law. So customary rules could also be applicable in this regard, but of course treaty provisions is quite enough for this. As for judges and prosecutors and all those who prosecute the war crimes, I always recommend them to and show and send them the link, and I'll send you as well the link to the database of customary international humanitarian law rules, and each of 161 custom has a cross link, I can say, to the treaties, and you can easily find the necessary treaty provisions to each of the violations, each of the rules in IHL. So it's easy. It's like what our lawyers like codified. It's a code with commentaries. So it's a code of IHL rules with commentaries. The fantastic choice for every lawyer in continental system. As to my knowledge, there are no, or maybe I don't know, there are no proceedings on deportation in other countries. But nevertheless, for example, Germany's Federal Criminal Police Office has received, its recent information has received more than 300 tip-offs about possible war crimes in Ukraine. And they were taken from Ukrainians, moved to Germany, and this information was given by them. So it is very important to create such organizations as Sunflowers Project, who can also be in help in this regard. More than 80,000 war crime proceedings are now in Ukraine. And of course, you see that only 90 criminal cases on the deportation, not a lot. It is difficult to collect the information about the victims, and as already said, that this register will help us. Recently, on the 5th of April this year, a judge involved in the deportation of Ukrainian men from the territory of the temporary occupied, from the temporary occupied territories was sentenced in absentia to 10 years in prison. It was the first verdict on deportation as a war crime. Avenues of criminal prosecution, international jurisdiction. I'm sure that everyone knows that the ICC issued arrest warrants for Putin and Maria Lvova-Belova for alleged war crimes committed in Ukraine, the deportation of children. And according to Article 27 of the Rome Statute, Putin has no immunity from the ICC, even as a sitting president, so no Russian persona immunities for Putin in the ICC. It is, frankly, I was very impressed that such an important decision was made quite in a short period of time. And of course, you know that the ICC has jurisdiction according to Article 12, Part 3, 12.3. It's the so-called ad hoc jurisdiction, but it has, and it was already enacted, this jurisdiction. Was it an achievement or is it a challenge? Of course, the significance of this arrest warrant cannot be overstated. It means that the 123 state parties to the ICC are not only able, but they are obliged to arrest the president of Russia. It also means that the rest of the world can do the same, though they are not obliged to arrest him, but they can. Is it a challenge? Yes, it is a challenge, because you've maybe heard those discussions about the future of Putin's visit to the BRICS summit in South Africa, and South Africa has quite an experience of not surrendering the former president. For that moment, he was an acting president of Sudan, Omar al-Bashir, to the ICC, despite the issuance of arrest warrants against him. Another country that also said that it would not arrest Putin is Hungary, referring to the lack of national legislation in cooperation with the court. Of course, such a statement, Hungarian statement, is incompatible to the Vienna Convention on the Law of the Treaties, to Article 26 and 27. But the main question in this regard still remains whether there is and should be a mechanism to enforce the obligations of state parties of the ICC Rome Statute. The Rome Statute has no concrete provisions for enforcing the arrest warrants. The only possible solution in case of non-compliance is a reference of the matter to the Assembly of State Parties to the ICC. It is something like General Assembly in the United Nations. The ICC is an international organization independent from the United Nations, and it has its own Assembly of States parties. But it's only the discussion and it's only the reference of the matter. So no enforcement mechanisms in the ICC. And in the meantime, significant pressure on the non-cooperating states could reignite the risk of their withdrawal from the statute. We already seen it. But of course, it's not the case for Hungary, the member of the European Union, but it appears the political gamemanship that it's political games, they already began. And of course, Russia will fuel them. It is achievement because for now, recent developments, I found the article in Russian press that all children of Ukrainian nationals who were on holiday in Krasnodar Krai, Krasnodar region in Russia, and were delayed in returning, have been handed over to their relatives. It's the words of Maria Lvova-Belova. So they started the process of returning children. I'm delighted that this arrest warrant of the ICC was issued, and it frightened them, as I can imagine, and now they start returning. And the ombudsman Lubinets of Ukraine, he also mentioned that they started returning, and maybe this process will be even more intensive. In April this year, recently, the legal act prescribing the procedure for maintaining the unified register of deported persons, including children, was adopted as well. I already mentioned it. As for recommendations, there are several challenges, and the first is the proliferation of responsible bodies and lack of coordination between them. There are different Ukrainian body involved in this process and of returning the deported civilians and children. And the main Ukrainian body is Ministry of Reintegration of the Tool, which coordinates the return of Ukrainian citizens and children. The Ombudsman of Ukraine monitors this situation and participates in the returning as well. The Defense Intelligence Service, the Security Service of Ukraine, the Foreign Intelligence Service of Ukraine also exercise their powers in this area. The General Prosecutor's Office is working with the National Information Bureau and the National Police to identify the abducted children. And the Security Service of Ukraine is also competent in this field of prosecution. So lots of organs, no like coordination between them, or lack of coordination between them. I propose this recommendation to increase the level of coordination between them, and I'm sure that it's already have been done. Another challenge that the necessity to involve international organizations in the process of getting the information and returning of deported persons, especially children, and of course the recording of facts of deportation. So different Ukrainian bodies such as Ministry of Reintegration, Ministry of Foreign Affairs, the Ministry of Interior and State Migration Service could be recommended to disseminate information on the causes and consequences of deportation, because people they even don't know that they were deported. So they have to know their rights. They have to know that they can return, and Ukraine has to provide all the opportunities for their return. Involve international organizations and other intermediaries in the process of identifying deportees in order to assist their free return to Ukrainian controlled territory, or resettle them in other states. Develop an algorithm to obtain data on the location of deported. And here, in this regard, lots of NGOs would be in help. I can also salute to Ukrainian NGOs. They passed information, they communicated with the ICC, and they played a huge role in this process of issuance of the arrest warrants. Lots of Ukrainian human rights non-governmental organizations participated and collected the evidence and communicated them according to Article 15 of the ICC Rome Statute to the prosecutor. And now Russian non-governmental organizations are also collecting the information about deported children and help to return them. Their participation should be increased. And also the development of effective measures to returning deported children, restoring lost documents and issuing them to children born in temporary occupied territories since the 24th of February. And the last challenge is the necessity to improve of the work of the law enforcement agencies of Ukraine. But I also can say that the General Prosecutor's Office and especially the Department of War, they did and do a lot, and they involve lots of international experts, and taking into account this huge level of huge docket, huge amount of cases, they need help, of course, to prosecute all those crimes, to investigate them. And I'm delighted that lots of other states are involved in this process, lots of non-governmental organizations, and among them is Sunflowers Project, Sunflowers Foundation are also involved. in collecting the evidence, and the joint investigation team, with the participation of the ICC, they actively participate in this process of prosecuting criminals, and the ICC office will be created in Kiev. So lots during this year, lots of things have been done, and sometimes I hear the criticism that all states help Ukraine, but not other states in armed conflict. I would prefer not to mention other states, the names of other states, but you can find such criticism, for example, in the European Journal of International Law Talk. But I can say that it's not the results of 1 year. The armed conflict started 9 years ago, in 2014, and Ukrainian authorities already did a lot, and they have the necessary experience, but maybe they need more help from experts community and from international organizations, and I hope we'll have success in this regard. Thank you very much for your attention and participation in this webinar.